Hello there. It seems that the UK government has no intention of a face-off in court with Nicola Sturgeon over an IndyRef2. Now, why would that be? Yesterday on the BBC Mar show, when asked if the First Minister of Scotland would be taken to court over holding an unauthorised second Scottish independence referendum, Michael Gove simply said, "We're not going near there." Seems strange on the face of it, given Nicola Sturgeon's claims that the UK government would have to take her to court to stop an IndyRef2, on the basis that if Boris doesn't do that, it becomes de facto legal. But hats off to blogger Ian S. Smart for pointing out Section 29 of the Scotland Act 1998. This simply says, "An Act of the Scottish Parliament is not law, so far as any provision of the Act is outside the legislative competence of the Parliament." And it goes on to say that a provision is outside that competence so far as any of the following paragraphs apply, and one of the provisions is, it relates to reserved matters. So as the Union is a reserved matter, any Act of Parliament the SNP pushes through Holyrood to hold an IndyRef2 would not be law. It doesn't matter what they do, that Act would not be law. And as an Act can only be an Act after royal assent, one assumes that even with Her Majesty's signature on the paperwork, it would still not be law. That means that any referendum coming from an Act of the Scottish Parliament that has not been sanctioned by the UK government is automatically an unlawful wildcat referendum and null and void, as well as the outcome of any such referendum. There is no need for the UK government to challenge it through the courts, as Nicola Sturgeon, her SNP and the Scottish Greens would just be breaking the law and holding a worthless referendum that the Unionists could in all probability safely ignore. And remember that Sturgeon said she would not hold an unlawful referendum. And maybe this is what Michael Gove was hinting at. So what's your opinion on this? Please like and comment below.